Hello, everyone, and welcome to the SIAC Middle East webinar. This is the latest installment of the SIAC International Arbitration Webinar Series 2020. My name is Tom Snyder. I'm a member of the SIAC Court of Arbitration and a partner at Al-Tamimi & Company in Dubai. Today's topic is post-COVID, the future of international arbitration. And to address this topic, we have with us today four esteemed panelists who will be peering into their crystal balls to see what the future holds for this area of practice. I could probably spend the next hour and 15 minutes introducing them. They're a very accomplished bunch, but I'm going to keep the introductions very short and to the point so that we can get to the substance of our discussion as soon as possible. Our first speaker will be Professor Dr. Naila Komer Obaid, who is a partner at the Obaid Law Firm in Beirut. We also have with us Mr. Ian DeVaz, who is a partner in the International Arbitration and Middle East Practices at Wong Partnership in Singapore. We have Mr. Reza Motashami, QC, who is a partner at Three Crowns in London and who used to practice here in Dubai. And last but certainly not least, we have Mr. Adrian Tan, who is a partner with TSMP Law Corporation in Singapore. Today we'll be covering a variety of topics. We'll talk about what the future holds in terms of remote hearings, responses to COVID-19 by arbitral institutions. We'll talk about whether COVID-19 will be or will not be a catalyst for more efficient arbitration proceedings in the future. We'll look at potential legal challenges that might arise in relation to arbitral awards as a result of COVID-19 through the use of technology and remote hearings. And we'll try to give some time to thinking about what disputes might be coming down the pike. Now, since this is the Middle East seminar, we will be focusing heavily on the Middle East region, but our panelists will be considering some more general global trends as well. We're hoping to make this as interactive as possible. I think you'll be hearing from many of our speakers on most of the topics. We also invite all of the participants to put forth their questions. We will try to address as many of these questions as we can throughout the webinar. I will probably interject as much as I can with some of your questions. And we'll try to save some time towards the end as well to address the questions. So without further ado, let me go ahead and turn the floor over to our panelists. And the first topic, as I mentioned a few minutes ago, that we'll address is the topic of remote hearings. And to kick that off, Naila, could I ask you to jump in first and share your thoughts on remote hearings and what the future holds in that regard?
Thank you, Tom. I would like to thank SIAC for organizing this very timely seminar on the COVID and the future of arbitration in the region. Regarding the hearings and what happened during the COVID-19 in the MENA region. As you know, there were sometime a complete shutdown and some partial shutdown, with some hearings being delayed or postponed. However, many arbitral tribunals they organized themselves to have virtual hearings, depending on which institution they are under which institution they are acting. Of course, as you know, mostly in the MENA region, the framework legislation of mostly of the MENA countries does not provide for an express provision with respect to the use of new technology by arbitral tribunal, at the exception of the UAE. The UAE embraced its new law in 2018, and they expressly refer to the use of new technology by arbitral tribunal via video conference and other means of technology. Similarly, also the Jordanian new arbitration law of 2018, they also embraced a new provision with respect to the use of new technology by arbitral tribunal, and also to cross-examine witnesses under oath via video conference or other means of new technology. In the MENA region, we still have some disparity regarding the connectivity issue among the countries. We have a problem of internet connection. In some countries, this is not applicable to UAE because the need is to have at least 5.5 bandwidth, which is, of course, in UAE, you have it, they have it. However, in other countries, you see sometimes in the rural, it's not possible to have a good connectivity. However, in the other part of the country, for example, in downtown, like in Lebanon, you have good connectivity. So it means that in my experience, many arbitral tribunal, they had virtual hearing with respect to conference calls for the procedural management, case management conference call, or hearings for on specific issue, jurisdictional issue, or legal issues, using ICSID platform when for ICSID cases, or other platform used by other institutions, and also referring to guidelines, specific guidelines. It means that in the Middle East, we should be very cautious with respect to how to use the technology in order to be sure that you have the internet connection, the cybersecurity, and to also follow strictly the protocols, civil protocols or other protocols that need to be followed in order to ensure a smooth virtual hearing. Of course, you need to have the express consent of the parties in the region when the legal framework does not provide for a specific provision for virtual hearing or the use of new technology. Of course, arbitral tribunal should request the cooperation of the parties and counsel, and also they should issue a very detailed procedural orders when they are envisaging to hold a virtual hearing in the MENA region. This is my first thoughts, and any other question you would like me to address, I would be happy also to address it.
Great, great. Thank you very much, Naila. Reza, anything you wish to add on this topic?
Just a few points, Tom. Thank you. And let me start off by saying how wonderful it is to be able to join you all today remotely, and to thank SIAC for organizing today's webinar. Allow me to make 3 quick points in relation to remote hearings in the MENA region. The first point is that remote hearings in some form or another have been taking place in the MENA region for many, many years. I recall acting as counsel in an arbitration hearing in Bahrain back in 2012, and having to cross-examine a witness who was sitting in Kuwait over a Skype connection. It all went very well technically until the Skype connection suddenly cut towards the end of my cross-examination. And by the time it was turned back on again, the witness had left the building. But then it turned out it was the witness who had disconnected the connection because he had had enough of answering my questions. It's obviously a lot harder to do if you're sitting in the hearing room. The second point is this: I think the same factors that have pushed many national courts and tribunals to push on with virtual hearings apply equally in the MENA region. One of the first published decisions rendered by a national court on this topic was by the English court on the 19th of March. And to put that in context, that was before the general lockdown was belatedly ordered by the UK government. In that decision, Mr. Justice Tier rejected an application to adjourn a trial that was due to take place the following week. And he said this, and let me read out just a very short excerpt from his decision. He said this, he said, "The courts exist to resolve disputes. The default position now in all jurisdictions must be that a hearing should be conducted with one, more than one, or all participants attending remotely. I accept that for various reasons, in particular the geographical location of the expert witnesses, this exercise will have particular challenges. But it seems to me that having regard to the need to keep the service of public resolution of disputes going, it's incumbent on the parties to seek to arrange a remote hearing if at all possible." That's a very clear statement of principle, which is likely to become, if it hasn't already, I think universally applicable to all tribunals, no matter where they're sitting. And then my final point is this. I think there are two constraints on holding a remote hearing or a virtual hearing. The first is if there's an impediment under the arbitration rules or the arbitration laws that are applicable. I'll come on to mention arbitral rules later on. As far as arbitral laws are concerned within the MENA region, most of them now follow the UNCITRAL model law, and they empower the tribunal with broad procedural authority to organize hearings. As Naila has said, only a couple of them, the UAE is a very good example, expressly deal with the power to organize virtual hearings using modern forms of communication. And so I think the real constraint is going to become the practicalities, the logistics of it. And let me end with one example. I'm counsel in a case that was due to go to a hearing this week, as it happens, involving a ministry of a Middle Eastern government that had representatives and witnesses scattered across a number of countries in the MENA region. We had the other side, which had representatives split across two continents, tribunals split across Europe and Australia, a typical international arbitration proceeding. But we decided we couldn't proceed with a hearing, neither in person nor virtually. And I think the key determining factor was the constraints on ensuring reliable cross-examination of witnesses. A number of the witnesses were at home in jurisdictions without reliable broadband access. A number of them needed interpretation, which is difficult over Zoom and similar platforms. And we just couldn't make sure that everyone had access to the transcript and the arbitration records in a digital, reliable way. And so we ended up pulling the hearing. I think in most cases, perhaps virtual hearings will be possible, but that won't be the case in all instances. Thank you.
Thank you, Reza. And I think that leads nicely into the first question that we have from the audience. And that is, in your experience, are parties more prepared to dispense with witness cross-examination due to the various issues associated with the difficulty of using remote hearings? So, the question there is, are we going to see less cross-examination of witnesses with the growth in remote hearings, or are we going to forge ahead with those remotely, or at least for the time being, where the parties think it's essential to cross-examine witnesses in person, put it off for some time until we're able to do so? What are your thoughts on that?
Well, just to give my thoughts, and my practice is primarily as counsel rather than arbitrator, I think clients will not readily give up their right to cross-examine witnesses put up by the other side. So I don't see us moving to a more inquisitorial type proceeding without witness cross-examination.
Yeah,
Just,
I tend to
jump in
agree.
there.
Ian, please, yeah.
I think in my experience, ever since, well, I think from April or May onwards, when hearings sort of like went virtual, most of the hearings were for interlocutory matters, and we found that the tribunals and parties were more comfortable with that. I think with witness cross-examination, and I think we'll touch on this in other topics down the road, there will be constraints and limitations. And certainly, I agree with Naila. In my experience in the Middle East, I've come across some, shall we say, a bit old school arbitrators who prefer hard copies still. And I think to some extent, we can all relate to that. There are issues with internet connectivity and general, lack of familiarity with this new platform, this new environment we are facing. And obviously, there's another point, which is online advocacy. Looking to a camera, it's not quite the same thing as looking into the tribunal's eyes, reading the body language. And these are the nuances which I think need to be taken into account. Certainly for the oral evidentiary hearing, probably less critical for interlocutory and other procedural meetings.
There's one school of thought out there that virtual cross-examination can actually be more effective than in-person cross-examination under the right circumstances. Under the school of thought, the idea is that if you can have multiple cameras in the room where the witness is sitting, you have the ability to zoom in on the witness. You can ensure with those cameras that no one else enters the room. You can have large screens on your desk so that you get a clear view of the witness. And at least in theory, the cross-examination of the witness can be video recorded and treated like a transcript. So the tribunal can actually go back and see not only what the witness said, but how he or she said it. Do any of the panelists subscribe or potentially subscribe to the school of thought? Do any of you think virtual cross-examination might actually be as good, if not better, than the old-fashioned way of doing it in person?
I'm going to jump in, Tom, because wherever that school of thought is, I want to find it and blow it up. It's probably the dumbest school of thought that I've seen, and I've seen many. So this is not cross-examination anymore. If you have multiple cameras closing up on a witness, this sounds like more a police interrogation right in the basement of some police department. That's not the idea of arbitration. We're not doing with criminal cases. We're talking about commercial disputes. Our mode of evidence gathering has developed over centuries, literally by trial and error. So there's an idea of what is possible and realistic and practical and dignified. So it's not dignified to have someone cross-examined under conditions where there are multiple cameras pointing at different parts of his anatomy. And for that to be all recorded, and for some arbitrators to go home and view that over the TV. I think it's quite a stretch to say that this virus is going to bring us any benefits in arbitration, but that's a soapbox that I'll get onto later on in this webinar.
And Tom, I would just add to that, if I may. Don't discount the logistical difficulties. I was cross-examining a retired Egyptian judge through VC. He was in Cairo, I was in Paris only last year. He didn't speak any English, and so everything went through an interpreter. And I can tell you that it was an incredibly time-consuming and frustrating experience, merely to be able to get the judge, the witness, to find the relevant passage of a document in the relevant bundle took far, far longer than if we were all sitting in the same room. So I think It's wonderful as this new technology is, and to be able to see you sitting in multiple venues, it's not the same as all being in the same place.
I agree with Reza, Tom, but however, I am sure that the new trend in the MENA region is to embrace the use of technology for virtual hearing, specifically for case management, conference call, and for example, jurisdictional issue, to hear jurisdictional issue, legal issues. Of course, this will save time and cost. And I am sure that countries will revisit their laws on arbitration, and they will incorporate new provision, express provision to use new technology, even though if they are, most of them inspired from UNCITRAL modern law. But my advice is, if there is no express provision in order to avoid challenges or challenges against the enforcement of the award, is to request the express confirmation from the party that they agree to use virtual hearing and to use new technology. I agree with Reza that cross-examining witness is challenging. We need the logistics and the means. I had a hearing last week in an exit case. It went very well because the WebEx platform is very secure, and but it was a hearing on jurisdictional matter, on jurisdictional bifurcation issue. It went very well, but I don't know if we have several witnesses coming from all around the world with interpretation, several languages. This could be a harder. I think that arbitral institution should help the arbitration community and the user in order to have better use of technology. And I'm sure that they will implement several device in the future in order to help the user to use this new technology.
Okay, very good. I think there's a lot we could a lot more we could talk about when it comes to remote hearings. I know I've got several other questions I would like to pose to the panel, but I think let's keep moving on. And I think, you know, a lot of these issues do interrelate with each other. So I think we'll be sort of coming back and touching upon some of these issues in the next hour or so. I think one question I'll throw out there, and I'm not necessarily looking for an answer right now, but if throughout the course of the webinar, if you could, some of you could touch on this, and that is, you know, the question, you know, we've been talking about new technology, but the fact of the matter is a lot of this technology is not that new. You know, Reza, you referred to examining a witness 10 years ago using Skype. And so my question is, you know, as an international arbitration community, are we really being innovative in this COVID situation? Or are we really just finally being forced to use the tools more regularly that we've had all along? So let me just leave that sit with you for the time being, and feel free to come back to it whenever you would like. But let's keep moving. And Reza, I'd like to turn the floor over to you. We'll switch gears a little bit. And can you tell us about some of the responses to COVID-19 that have been taken by some of the arbitral institutions, and maybe what the role of the arbitral institutions is in all of this?
Sure, Tom. Arbitral institutions, I think we will all agree, have been very active over the past few months since it became clear that COVID was going to greatly disrupt the way that arbitrations, the way we had all gotten used to running our international arbitrations. And I think the measures that the institutions have taken can be split into three categories broadly. The first measures were the ones aimed at ensuring that institutions would continue to be able to administer cases and receive new cases, so that when they were forced to close their doors to their offices, they managed to open virtual doors to those offices to continue cases going. And in practice, this has meant institutions have moved to an entirely digital case management platform, requiring all submissions and correspondence to be filed digitally by email or uploaded to a secure portal. And in this respect, you know, COVID has accelerated the trend that was already well underway. COVID's also meant that many institutions, notably the HKIC, Delos, the Chartered Institute, have issued guidance notes, checklists, protocols for arbitrators and users on how to run a virtual arbitration and identify new issues that should now be considered in organizing proceedings. Other institutions, notably SIAC, has been running a series of webinars, of which this is the latest, looking at issues of practice and procedure that COVID has thrown up, such that there is now plenty of advice on how to manage an arbitration in the current digital and virtual environment. And where can you find all this information? Well, if I may be permitted a short plug, a number of practitioners have established a one-stop portal, pulls together all of this different learning. You can find it at virtualarbitration.info. I encourage you to visit the site. The second set of measures taken by institutions then in response to the travel restrictions and social distancing measures that have been imposed has been to ensure that cases don't grind to a halt because we can't organize in-person hearings and procedural meetings. And so the institutions have been working together with the arbitration hearing centers to put in place systems and procedures to enable the organization of virtual hearings, as we've been discussing. Now, once again, this is an acceleration of an existing trend. Lots of hearings, especially CMCs and interlocutory hearings, were already taking place remotely. I note that ICSID has recently reported that fully 60% of its 200 hearings and first sessions held last year in 2019 were held remotely. What is novel, I think, is offering arbitration users what are called hybrid hearing solutions that combine hearings in a safe, distanced environment with virtual elements. So, for example, 3 leading arbitration centers, Arbitration Place in Toronto, Maxwell Chambers in Singapore, and the IDRC in London, have come together to form the very impressive sounding International Arbitration Center Alliance, which is aimed at, and I quote, providing a seamless dispute resolution experience tailored to the locations and needs of the participants. What does that mean? Well, I think the aim is to allow participants to attend either via socially distanced group hearings or via their homes and offices remotely. So some people will go to Maxwell Chambers or the IDRC and sit in a socially distanced setting. Others will dial in, and everyone will have access to a digital case management and hearing platform. And I think if border restrictions continue, such as to effectively rule out long-haul travel, but then we have the possibility of short-haul travel within particular regions of the world, such as within the EU member states or within Asia-Pacific countries, then I think hybrid hearings are really the future, at least in the medium term. And what is potentially revolutionary, I think, is this has enabled arbitration centers to really compete for the first time with each other across global borders. So previously, if you had a hearing in Singapore, you would look at the offering of Maxwell Chambers and maybe look at a handful of downtown hotels, but that was your shortlist. Now you can look at the offerings of the leading hearing centers across the world, no matter where they're located, and I think that will inevitably mean better service at a more competitive offering for all users, which is good. My final and third point, perhaps the most substantive initiative that institutions have taken, have been these guidance notes to parties and in particular arbitrators, reminding them of the powers that they have under the existing rules to organize virtual or remote hearings and to press on. The ICC's guidance note issued in April is a good example of this. It deals with a whole gamut of issues that we don't have time to address, but on the controversial issue of proceeding with hearings, the guidance does say that arbitral tribunals can press on with a virtual hearing against the objections of a party. The guidance is necessary in the case of the ICC because the current rules of arbitration issued in 2017 don't expressly deal with the issue of remote hearings. They only provide the arbitrators with broad procedural authority to organize the proceedings after consulting the parties. And so it's not surprising that the ICC is going to be expressly addressing the tribunal's power to organize virtual hearings in its next iteration of arbitration rules that are currently under consideration and are going to be issued before the end of the year. I think the ICC is not going to be alone in that. The ICDR AAA is also looking at revising its rules, including to deal with the issue of virtual hearings. And I wonder whether other institutions, including SIAC, whose 2016 rules don't expressly deal with this idea of remote hearings, are also going to be doing the same. As for what these rule changes will eventually look like, well, while we don't have a crystal ball that will tell us the final outcome, I think we can hazard a guess by looking at the LCIA rules issued in 2014, which deal with the issue of virtual hearings in some detail. They say, and I quote, that the arbitral tribunal shall have the fullest authority under the arbitration agreement to establish the conduct of a hearing, including its date, form, content, procedure, time limits, and geographical place. As to form, a hearing may take place by video or telephone conference, or in person, or a combination of all three. End quote. That's really comprehensive. And I suspect that the rules of most institutions will end up covering the same ground in their forthcoming iterations.
Thank you, Reza. You know, I think it's interesting. You mentioned the ICC guidance note that made clear that arbitral tribunals can proceed with a remote hearing over the objection of a party. I think that's probably particularly important in the context of the ICC because their rules have a provision that says that the arbitral tribunal shall hear the parties together in person if any of them so request. So that phrase in person arguably set a higher standard than other institutional rules. For example, the SIAC rules don't have that phrase in person. Does that phrase in person cause any concerns for you or for any of the other panelists?
Well, let me answer it this way. It doesn't seem to cause any concern for the ICC court, right. Having issued its guidance. I understand, and I'm afraid I don't have the wording before me, that the French version of the rules don't have the in-person language. They have a more generic type language, and that's given comfort to the ICC court to be able to say that in person doesn't in fact mean in person. It means all together. And
arguably, video conferencing means in person. I mean, you and I are talking to each other in person. We're just far away from each other. I have maybe one other question for you, but let me just pause and see if any of the other panelists want to jump in on these points relating to arbitral institutions.
Well, Tom, I think Reza has pointed out quite accurately that there's the ICC guidance note. I think the HK IAC, Hong Kong IAC, has also come up with guidelines for virtual hearings. There is a Seoul protocol on video conferencing for international arbitration. And CIR has come up with a guidance note as well. But all these guidance notes don't talk about the important issue, which I think one of the questioners has asked, Akbar Adi. He says, how did the panel view the impact of procedural amendments in terms of conduct of hearing virtually as opposed to in-person hearings agreed upon by the parties at the stage of enforcement under the New York Convention? So we come back to this idea that arbitration is a consensual activity. Like all consensual activity, it comes with a whole baggage of preconceptions. I agree to arbitrate my disputes with you under this type of condition. And our understanding is that we're going to have an in-person hearing, and it's not a French in-person hearing, but it is in-person in the sense that we're all physically in the same room and we can resolve this dispute. I understand that the situation has changed, and I understand that we can't do that anymore. We can't all be in the same room, and we can't have the arbitration the way we envisaged. So my answer might be, let's not have an arbitration. Rather than, let's push through an arbitration that's different from what parties have agreed to. So I think it is open to a party to challenge and say, well, now that there is this COVID situation, there's a pandemic, we can't fly to each other's countries to have our arbitration, then let's not do arbitration. Let's do some other type of dispute resolution. Maybe let's go to court. And this is where I think the real innovation starts. It's not about technology. It's not who has the better platform. It's who has the better set of procedures. So it's going to be a race, not just between different sorts of arbitration centers, but also between arbitration and litigation. Because if the court system can come up with a faster, better, or more efficient way of resolving disputes, that actually means that more people will go to court rather than arbitration, because court is compulsory, arbitration is consensual. So the arbitration community has got to react much faster to come up with universal procedures and a way to enforce them, and a way to say, not only are we going to follow the same set of rules, but we're even going to decide on the same sort of technology platform. Because is it going to be Zoom? Is it going to be Skype? Is it going to be WebEx? Is there going to be a difference? There will probably be people arguing for one over the other. So as the arbitration community has got to, as soon as possible, agree on the common guidelines before the courts beat us.
So for you, it's really about procedural innovation, though of course technological innovation is going to be a part of that. And I think that leads to an important question. You referred to the need to agree on the sort of online platform that parties are going to use for an arbitration. And just to tie this back again to the issue of arbitral institutions, do you think arbitral institutions should offer particular platforms? In other words, say that if you're going to arbitrate at SIAC, then you're going to use, whether it's Zoom or what have you, but you're going to use this particular platform.
Yes,
should the institutions go that far?
Absolutely, because there are things that different platforms offer. Number one is level of security and privacy. Number two is stuff like, can you record it? Can you edit? What is the format that you come up with when you record? Is it MP4 or so on? So we have to drill down to see which is the most effective type of technological platform that we can use that will be safe, hack-proof, and that will offer the best documentation for what is going on. There'll probably be so many other considerations that I haven't thought of, but it's definitely important for each arbitration center to say, we are going with this platform and we have trialed it and we find it the most reliable. And it's got to be spelled out in the rules, actually. That's my suggestion. Put it in the rules, which platform we're going to use.
May I intervene, Tom?
Please.
I agree with Adrian. I think that during this pandemic, arbitral institution, international arbitral institution reacted extremely well to this pandemic in writing guidelines, in helping the arbitral community, in explaining how to use the platform, new technology, etc. However, I think that we all need to be more innovative and to reinvent ourselves in order to save the integrity of the arbitration proceedings. And I agree that now institutions should use the tools to be more competitive than the other, and to help the users, the arbitral tribunals, parties, and counsel to use a specific platform in order to make our life easier. For example, I gave the case of the exit. It was very easy for us because we all logistical matters with respect to transcription, to the use of the bundle of documents, to if you have any also translation, interpretation. So all of this is taken care by the institution. In my view, other institutions also should take the lead in implementing new technology and platform for the users. And this will make the difference to save our institution, to save arbitration, and to be sure that there will be more and more arbitration in the future, and to save cost, of course, to save cost and be more efficient.
So a theme that I hear emerging is that the future is going to be competitive. Arbitral institutions will need to compete with one another to provide these platforms. And the international arbitration community is going to be competing with other forms of dispute resolution, the courts in particular, to be more efficient and to be the dispute resolution method of choice. And I think that probably leads us nicely to our next topic, although it's a topic that we've already touched upon in many ways. But Adrian and Ian, I'd like to hear from you on your thoughts on whether this COVID-19 situation is going to be a catalyst for more efficient arbitration in the future or not.
Well,
Adrian, do you want to kick off?
Yes, Tom. So I think we have to view the COVID-19 pandemic as first and foremost a health crisis. So it's gonna, as a health crisis, which we see no end in sight, we're not sure how it's going to pan out. And it's quite hard to say this is going to be a catalyst for anything. After the disease outbreak, yes, there will be a dispute outbreak. And this dispute outbreak, I think, is borne out by a survey that I just saw from Legal Media Group, which is, I think they run Asia Law and Benchmark and other in-house journals. So they surveyed 400 in-house counsel with legal departments around the world. And these legal counsel are the sort of clients that all of us are going after. And the findings are quite interesting. Key takeaways, well, globally, law firms can expect in-house counsel to send them a wave of COVID-related litigation work in the next 3 months. So that's a positive. We're going to experience a wave, but this time it's a good wave. It's a wave of COVID litigation. And coming with that is also going to be another wave, a wave of requests for us to reduce our rates. So that's coming out in the survey as well. It's no big surprise, I think, because of the economic situation. There will be a rise in litigation dispute resolution of about 31%, according to this survey, which is more than double, 15% last year. So twice as much litigation. And the extra work that's created apparently is going to be on contractual disputes, followed by labor and employment and compliance issues. So it's quite an obvious hierarchy. We're going to see a lot of contractual disputes, and then labor and employment related, and then compliance issues and corporate governance issues. So we can look forward to that, albeit at lower rates. The next question is which type of dispute resolution platform we're going to opt for. Since the default if we have no arbitration clauses, since the default is court, then most of this work is going to court unless we can divert it. And right now, if I'm going to sit down with the client and say, let's go for arbitration, he's going to ask me, what's arbitration all about? How does it work? And in the old days, I could say we would go to an arbitration center, people will fly in, you could get a lawyer from another country fly in and be your counsel. You could get arbitrators fly in and be part of the tribunal. But I'll find it very difficult right now to paint a picture of what arbitration is going to be like 1 year down the road or 2 years down the road. And for that reason, it's going to be quite hard for me to tell my client, let's go for arbitration. Let's agree to this arbitration contract. So I see these difficulties, which are temporary in nature. They can be resolved, but we have to address them quickly. Webinars like this help because we all start focusing on the big questions. And for me, we have to develop very nimble set of procedures to address remote hearings as soon as possible. So that's my take, Tom.
Ian, what are your thoughts on efficiency?
If I can just offer a slightly different take from Adrian, and why I think that COVID is a catalyst for virtual hearings. I don't think we are there yet. We're quite far away from this being the default modality, but I think we are on the path of no return. And I say this for a few reasons. The first is that one of the greatest criticisms of arbitration is that it was just too expensive. It was just getting more and more expensive. We've seen so many protocols on containing costs in arbitration. And this is really ironic because in its early days, arbitration was touted precisely because it was fast and cheap. And those advantages have just now become disadvantages. Now, if we just think about virtual hearings and cost savings in terms of travel, if you have a three-party, three-man tribunal, the accommodation costs, the airfare costs, that will all be saved. The printing of hard copies would be saved as well. And then also for fixing of hearing schedules, it's so difficult to get a hearing date if you're fixing a hearing date with a three-man tribunal. This is sometimes fixed as far as 18 months in advance. So with virtual hearings and coupled with the lack of international travel, I think we could get those hearings fixed much more quickly, virtually. And obviously we would also reduce the need for voluminous documents. Now on the Zoom platform, as I think they have on Microsoft Teams as well, we have this very unique function, which I don't think is available on Skype, the share screen function. And I'm just thinking, I haven't personally been involved in a hearing using Zoom, but could that not save a lot of time? Instead of saying, now everyone in the room, please pick up bundle 427, turn to page, B2. Here is the document on the screen in a flash. Let's all look at it. And this is my question. And I think it will make for more efficient hearings. And I think that this is probably the way we are heading. I think arbitral institutions have already come up with protocols and guidance notes mentioned earlier, supporting this and facilitating this. So I think we are very much on that path.
So you've raised, both of you have raised a lot of very good points there, right? So Ian, I think you're saying that in terms of cost and time efficiency, we're going to see some improvement. Clients are going to save on having to purchase plane tickets and pay for hotel rooms and the like. Of course, the related issue, and less printing of paper, the related issue there is not only cost savings, but sort of a positive impact on the environment. We as arbitration lawyers, I think think we're hardwired to jump on airplanes and travel around the world. And I know many of us are craving to do that again, but it does leave a pretty big carbon footprint. I know there have been some initiatives in the international arbitration community to cut back on that. But in addition to the cost savings, the other efficiency dynamic or angle is the hearings themselves, the proceedings themselves. And as you point out, it might actually be easier to take people to an electronic bundle, put it up on the screen, share it with everybody else. Although earlier we heard sort of the counterpoint to that from Reza, who talked about doing a hearing with a witness and how difficult or challenging it is sometimes to get the witness to the right, making sure they have the right document in front of them, whether it's in paper or on the screen. But there is plenty that we can talk about in terms of efficiency.
Well, Tom, just coming back to that on cost savings, I want to put something on the other end of the scale, which is we have to invest in new stuff. So all of us are going to say, we don't have to get on planes and fly business class anymore and stay in 5-star hotels. Great, that's a savings. That's good for the carbon footprint. But what's bad is that we're all going to ramp up on our servers. We're going to buy cameras, microphones. We're going to have to rent special rooms, which are soundproof and which have special conditions. We're going to have to go and train all our staff on data protection, on security. We even have to retrain ourselves as to how we present in court. So I'm old school, to use the words of Ian. Old school in the sense that I stand up when I talk. I have to wear a suit. I have to look at people. I have to use my arms and point at stuff. But now we're all going to be YouTube influencers. We're all going to focus on how to present from the chin up. That's all people are going to see with us. We're all going to focus on how we're going to have advocacy just by raising our eyebrows and saying, let me share screen on this. And then the arbitrators will have to say, hang on, how do I get my highlighter onto the screen? And so the tribunal has to retrain as well. They have to be weaned away from post-it notes and yellow highlighters, and they have to think of new ways of remembering pages and page numbers. So there is a huge cost over there. So I'm not totally sold on the cost savings idea yet. Though I do think on balance, it will be good for the planet, and Greta Thunberg will give us the thumbs up.
And Adrian, I think the other thing you're saying that is that we as arbitration lawyers and arbitrators are going to have to learn new skills.
It's back to school.
Advocacy skills. It's back to school, yeah.
Back to school.
Yeah. Now, that ties in to a couple of questions that we've had raised, and I just want to divert to those for a moment, and they relate to issues of security. Kunal Kumar raises a good point, which is basically one of the points that you just raised, Adrian. And he says, what about the cost involved in the protection of data, security from hackers, and huge data management and training of our personnel? So, this new technology, while it's going to make things more efficient in some respects, will bring its own costs along with it. And who's going to bear those costs? At the end of the day, law firms will have to invest in them, but at the end of the day, it'll probably go back to the users of arbitration. Would you agree?
Yes, in fact, Tom, I'm thinking now I have to set aside a room in my office, just a meeting room, and I have to retrofit it out for a hearing, so that if I have to go for a hearing, that's the room I'm going to use. But then I think, what if my partner has a hearing on the same day? Well, he gets to have a room as well. So we can have set aside 2 or 3 rooms purpose-built for hearings. Where does it end? Oh, maybe I could go to Maxwell Chambers. They have rooms too. But that's also a limited supply. So I think the real estate consideration is a real consideration. And it's something we've only started to think about right now.
Now, related to that question is another issue that we've sort of touched upon. And this question is from Joseph Siadan here in Dubai. And I think his question is sort of the nexus of these security issues that we were just discussing, but also the disparity issue that I think Naila touched upon earlier. You know, in the cities, in some cities we have excellent Wi-Fi connection. In other cities, more rural areas, we don't. And Joseph's question relates to you know, deep fakes and cyber attacks and concerns about the use of virtual technology and arbitrations that are seated in developing countries that lack the necessary supporting infrastructure. Any views from any of the panelists on this point?
I said previously that we need to reinvent ourselves. We need, as arbitrator, if we decide that we will use a virtual hearing, any platform, we need to ensure that we have, of course, a meeting room for the hearing, and of course to ensure that we have all the protection via our IT and all new technology. Of course, we have to invest. Of course, there are some disparity between countries, and here I'm referring to the MENA region countries. However, and it's also expensive in some countries. For example, in Lebanon, it's very expensive. However, as arbitrator, as users, counsel, and parties, we need to cooperate ourselves. I think that the most important matter in order to preserve the integrity of the arbitration is also to ensure due process, to ensure also that each party will have the opportunity to defend itself properly, and all of these matters should be taken into consideration by arbitral tribunals, by counsel and parties. Of course, we have a lot to do. Of course, we have a lot to invest. However, in order to remain in the market, we need to do so.
And Naila, you mentioned due process, and I think, you know, again, a lot of these issues overlap with each other, but I think that sets us up well for the next topic, which again, we've touched on a bit. But Ian, if we could turn to you, what potential legal challenges do you see coming down the pike, you know, relating to remote hearings and the use of technology in arbitration? And are any of these challenges going to be successful?
Yeah, thanks, Tom. I think, you know, as lawyers, we have to be creative. And typically, if you want to challenge an arbitral award, try and set it aside, you're going to have to fall within one of four very narrow limbs. And I think the most obvious one that lawyers will try to take advantage of is the breach of natural justice, the lack of due process. The model law, Article 34, talks about the inability to present one's case. And I suppose arguments on this can be made from two fronts. The first is that, look, we're in different time zones. You know, my alertness levels are going down. That's maybe 6 p.m. and yours are going up, you know, and my witness, who is probably, you know, somewhere in his siesta time, is not very alert. And so we were not able to conduct this hearing in a fair manner at odd and differing hours. The second is a point we spoke about earlier, which is the connectivity issues. And ironically, I was on a call this morning, an hour long, and just after the hour mark, I saw a few people just dropping off the call, and no one quite knew when they dropped off, and we had to sort of like rewind, and I had to repeat myself. And I shan't name the platform, but it's one of the more reputable ones. And it was a paid subscription, so this wasn't the Zoom cut you off after 40-minute platform. And still we're having this in Singapore. which is touted for its infrastructure and its digitization. So there will be these issues, and you can imagine if a witness gets cut off or counsel can't properly be heard, then this will open the door, I think, to challenges of due process. I was unable to present my case properly. The other broad point on challenges would be that this is not what I signed up for. And this, I think, is what Adrian mentioned earlier. And the port of call would be your arbitration agreement, the arbitral rules, even the lex arbitrae. And you say, where does it say that, leaving aside guidance notes, which have no, which the parties didn't sign up to, where did I agree to sign up for virtual hearings? So this renders the entire hearing to be on a completely and radically different platform. I didn't sign up to it, and therefore I have not presented my case as well as I could have for all the reasons we've mentioned earlier in this webinar. And finally, as with all remote hearings, there are inherent problems with witness coaching, and even on this platform, the 6 of us here as panelists can send each other private messages. I can assure you we haven't sent any yet, but witnesses can be coached in this way, right? And even with your 360-degree cameras, there will be limitations. There will be challenges. So, and then just to answer your question, Tom, how likely are these challenges to be upheld? I think we know it's very difficult to set aside the general judicial policy is to uphold arbitral award. So it's going to be difficult. The threshold is very, very high. And, the courts will be looking for something which is irrational or capricious. And it does accord, substantial procedural deference to tribunals. So I think it's going to be difficult to surmount that hurdle. But I'd be happy to hear from my fellow panelists on their views on this.
Thank you, Ian. As would I. Adrian, Reza, Naila, any thoughts on the likelihood of the potential legal challenges and the likelihood of success?
And I think, for what it's worth, that we will see lots of legal challenges to awards brought by unhappy parties who feel that they've been corralled or forced into having a virtual or a remote hearing. Whether those challenges are going to be successful, I'm less certain of. It has never been easy to set aside an award in a sensible jurisdiction on the grounds of violations of due process. Courts appreciate that parties have made a decision to go to arbitration, and that means that the arbitrators are entrusted with a large degree of procedural autonomy. So unless the arbitrators are trying to do something that is manifestly unreasonable or unfair to tilt the balance in favor of one party and against the other, I suspect these challenges are not going to be successful. But it will still involve additional cost, additional complexity to have to address these challenges, which is why I welcome the initiative of the institutions to revise their rules as soon as possible to address this point and to bring some certainty. The guidance notes, frankly, are not worth very much, I think.
I agree with Reza. However, I am of the view, and I know that many arbitral institutions that are now revising their rules in order to incorporate specific provisions with this respect, using virtual hearing and also to implement new technology, which will render the challenge less burden on our shoulders. However, in all cases, as arbitrators, we need to be very careful. We should, as I said, draft very precise procedure order in order to encounter every and each possibility in order to avoid challenges of the award. Of course, Ian mentioned time zone. In my arbitration last week in my virtual hearing, we had participants from United States. It was 4 o'clock in the morning. From other part of the world, it was 9 o'clock, 4 o'clock, 11 o'clock. It means that to have a virtual hearing for several days with these constraints, it's sometimes difficult. For 1-2 days, I think it's possible. However, to have a hearing for 2-3 weeks with all of these constraints, it's a challenging. And we will have to reinvent, as I said, ourselves, to be creative in order to see in the future how we have to deal, to consider in the future how we have to deal with these challenges regarding the virtual hearing and other use of technology.
And if I may just add something to what Naila has said, I beg your pardon, and pick up a point that Adrian made earlier where I disagreed with him. I think the point, Adrian, you made was that now that we don't get on planes and have to travel to go to hearings, suddenly we're going to have a lot more availability and ought to be able to schedule hearings much more efficiently. I actually disagree with that. I think that for the reasons that Naila has mentioned, I think we will not be able to have 7-8 hour sitting days if we're forced to stare at one or more screens and people are split across different time zones. I think the future is more likely to involve shorter sitting days, maybe only sitting for 3 or 4 hours at a time. But that means that a regular 2-week hearing is going to now take longer than 2 weeks. So unless arbitrators and counsel are able to schedule multiple hearings on the same day, given that each one is going to be only, say, 3 or 4 hours long, then I think things are going to take much longer than they used to in the past.
Actually, Reza, you're right. I did not consider this point that if we're talking about different time zones, it's impossible to have long hearings stretched over several days. And it just occurred to me that we're also talking about a different type of fatigue. So if we're in person and we're all in the same room and we're presenting to each other, we can get tired and we can take breaks, but there's still an energy in the room. It's a different sort of fatigue if you're sitting and staring at a screen for 8 hours or 6 hours on end. And if that screen is located, let's say you're doing a hearing at 2 a.m. in your house, that's going to create issues for your family. If you're going to do it over a week, it's going to give more work to matrimonial lawyers. If you do it in the office, we have to re-engineer our offices in different ways. So I do think that we're going to have different sort of fatigue set in, and maybe that means we can't take on as much work as I thought originally we could. So that's a good point.
Let me ask the panel this question. This is a question from one of our audience members, and I think what I heard from the panel is that there is consensus that A, there will be legal challenges, but B, for the most part, those legal challenges are probably unlikely to succeed. But C, it would nevertheless be good for arbitral institutions to update their rules just to make sure that these issues don't rear their heads too much in the future. The question from Esha Jain is a related one. And Ian, you may have touched upon this a bit, but do changes need to be made to the UNCITRAL model law and to national arbitration laws in this regard? Or are such changes really not necessary?
I am of the view that some changes, some amendment should be made to the UNCITRAL arbitration law and to also other laws, domestic laws worldwide, in order to be more arbitration friendly and in order also to take into account that there will be a use of virtual hearing. There will be an increasing use of virtual hearing, but in specific cases, maybe for medium and small sized cases. However, for mega cases, I think that the in-person hearing will remain the best choice for the parties, counsel, and arbitrators.
Okay.
And Tom, I think this might be making its way into the drafting of contracts as well, and arbitration clauses. I could very well see parties now providing that they will not challenge or agree that they will not challenge an arbitral award solely on the basis that it was held virtually. And this might be then mirrored in the institutional rules. Already some of the guidance notes and protocols suggest that parties, in anticipation of this, agree in advance that they will not rely on this ground as a challenge.
Good point. Good point.
It's a good point, Ian. However, if it's a matter of due process or right to be heard, you should be very cautious. Even so, if the parties withdraw any challenge with respect to virtual hearing or other, you need to take into consideration also this public order matter.
Now, we unfortunately are running short on time. We only have a few minutes left, and I want to turn briefly to our last topic. And Adrian has already alluded to this. The last topic is what disputes do we see coming down the pike? Now, as Adrian said, one of those is probably more marital disputes, especially among arbitration lawyers and arbitrators. Let's hope there aren't too many of those. But Nayla, on a more serious note, what disputes do you see coming down the pike as a result of COVID-19, both in the region and more generally?
Definitely, I will see more contractual disputes coming from force majeure clauses. The theory of exceptional circumstances is COVID-19 is a force majeure. At the beginning, maybe yes, but now after 1-2 months, maybe it's related to exceptional circumstances or it is previsible. Also, more construction disputes due to delay, disruption in the region, of course, in the MENA region, delay, disruption, and other problems related to COVID-19. Of course, worldwide supply chain disputes. There will be many supply chain disputes worldwide. Energy sector dispute. Also, I assume that there will be an increasing number of energy-related disputes. Dispute in banking and finance sector. Already I mentioned the case of Lebanon. We are witnessing an increasing number of disputes from the banking sector. And also I expect that there will be also an increasing number of investment state dispute in the region and worldwide.
Thank you. Any other thoughts from our other panelists on what we're likely to see?
I'm going to jump in and say labor and employment, because there's going to be issues. There's a tension between employers and employees as to when to come back to work, what are safe working conditions, and so on. And I think this type of issue has never been thought about, but it's certainly arbitrable. And so I'm gonna say that's gonna happen.
But Adrian, it depends from the countries. For example, in the MENA region, they are not arbitrable, and they will rely on the court. It depends from the applicable law.
I agree with the list of potential disputes that Nayla has outlined. I think the focus has to be on the sectors that have been hardest hit. So hotel, management contracts, tourist facilities, retail, etc. My one caveat to this is the following. Those companies that are starved of cash flow because they've not been able to provide services or provide goods to customers, they are going to be reluctant to be spending money litigating disputes. That may mean that disputes are going to be delayed or postponed rather than cancelled altogether, but I think cash flow is going to be an important part of the equation.
Which brings us back to efficiency. Arbitration needs to be more efficient. I think we could go on, but unfortunately we are running out of time. We did try to address as many of the questions as possible. I know a few more have come in here at the end. I'm sorry we weren't able to get to those, but I'd like to end with one final question for the panelists, I'm going to do a round robin, ask each of you for your answer, which will simply be a yes or no answer, I hope. And that is, are you optimistic about the future of international arbitration? And I'm just going to go down the line as you appear on my screen. Ian, are you optimistic? Yes or no?
Yes, I am.
Nayla?
Yes, I am. But we have to take all measures that already I discussed.
Okay, well, you're optimistic, but we need to keep at it. Reza?
Yes, we can, to paraphrase a well-known saying.
And Adrian?
It won't be arbitration as we know it. And this is to paraphrase somebody from Star Trek. It's arbitration, Jim, but not as we know it.
The only constant is change, right? And so we need to adapt, we need to learn more skills. On that note, I'm going to go ahead and wrap things up. I would like to thank all of our panelists very much. I'm biased, but I thought it was an excellent webinar, very interactive, very provocative, very interesting. I'd like to thank the SIAC for making this possible, and the business development team there in particular for all the logistical assistance. And I'd like to thank each and every one of our participants. I hope you found it useful, and I hope you'll tune in again for future SIAC webinars. Thank you all very much, and hope to see you soon. Thank you.
Thank you.
Thank you.